Welcome to Spoken Injustice, where we put the criminal justice system in the dock. As you know, in our unique trial, we have so far focused on the charges on indictment. However, today we are turning the spotlight on the defendant in our dock, the criminal justice system itself. We will examine its character, good and bad, calling character witnesses where appropriate, and determine whether it is truly capable of reforming. While the crime itself is typically the central focus in a trial, examining the defendant's character plays a crucial role. The prosecution highlights defendants' flaws, while the defense emphasizes their virtues. Additionally, defendants' social and familial contexts provide a complete picture. This is exactly the aim of this video today. So get comfortable and join us as we scrutinize the criminal justice system aims and objectives. We'll explore how these have evolved over time, the reasons for these changes, and whether additional reforms are warranted and justified. As usual, make sure to stick around for the long haul to gather all the facts to form your own opinion. First, we'll start by explaining the context and why now is the perfect time for these discussions. Though as Spoken Injustice we do not do politics, we could not fail to mention that on the 5th of July 2024, we gained a new Prime Minister and a new government. Whilst I'm still processing on a personal level the idea of having Keir Starmer, one of my former bosses, as a Prime Minister, the encouraging aspect as far as our mission of humanizing our criminal justice system is concerned, is having a Prime Minister who is a lawyer with a deep understanding of our criminal justice system. This background should inspire confidence that he will prioritize reforming the system. In his first speech as Prime Minister, he emphasized that the country has voted for change and that this change must happen immediately. We hope that his determination and enthusiasm will persist throughout his leadership. Whilst he and Shabana Mahmood, the new Justice Secretary, will have to deal with pressing issues such as prison overcrowding and the legal aid crisis, which need immediate attention, we hope that they will find the time and the determination to overhaul our criminal justice system. Over the past 15 months, we have highlighted the issues that make it clear that a major radical change in our criminal justice system is not just desirable, but rather imperative. As you know, our mantra is that the needed change must focus on the system's actors. What do we mean by this? While some legislative reforms are necessary, and we have proposed several which you can find on our website under the new tab Reform Proposals, the urgent change must target the system's culture. A radical transformation is needed to ensure that everyone involved in the criminal justice system is truly engaged in serving the subjects it aims to protect and the rights it aims to uphold. Let's break this down into clear bite-sized sections, starting with the basic question: what is the criminal justice system? The criminal justice system is a collective body responsible for maintaining law and order and administering justice. In the UK, its key components include law enforcement agencies, most notably the police, prosecuting agencies, most notably the Crown Prosecution Service, barristers and solicitors, who together constitute the defense, the courts, the prison service, and the parole board. Each of these components has specific functions that, though interconnected, must largely remain separate to ensure that the criminal justice system delivers fair and just outcomes. Law enforcement agencies handle investigations. Prosecuting agencies manage prosecutions. The defense ensure that the rights of the accused are upheld. The courts are responsible for fact-finding and applying the law to the specific case, as well as ensuring that legal processes and procedures are adhered to. And the prison service and the parole oversee the punishment and rehabilitation of the offender. Having established what the criminal justice system is, the second question we must ask is, what are the aims of the criminal justice system? This is somewhat a more complicated and not so straightforward question. In general and in broad terms, the aims of the criminal justice system are maintaining law and order, administering justice, and protecting rights. But what does this actually involve? All those aims are interconnected and there is no clear cut between them. However, we can broadly say that maintaining law and order is a dynamic and complex task that involves the coordinated efforts of various entities and communities, including law enforcement agencies, legal frameworks, community engagement, working together to ensure public safety and the adherence to laws, with public safety at the core of these actions. Administering justice seeks to ensure fair trials where guilt or innocence is determined based on evidence presented in court, and appropriate punishments and rehabilitative measures administered. Protecting rights involves safeguarding the rights of the individuals involved in the criminal justice process. This leads to our final question, that is, what are the rights which are protected by the criminal justice system? The rights are different depending on the individual involved in the criminal justice system. And who are the individuals? These are the suspects, who in time may become the defendant, the victim, the witnesses, and the public at large. Let's take a look at each in turn. The suspect rights include the right to silence, partly limited over time, the right to an interpreter, the right to legal representation, the right against unlawful searches and seizures, the right to be informed of the charges, the right to humane treatment. The defendant's rights include the right to be presumed innocent, the right to a fair trial, the right to call and cross-examine witnesses, and the right to appeal. The victim's rights include the right to be heard, the right to be kept informed about the progress of any investigation or prosecution, the right to be protected, the right to access support services, and the right to compensation. The witnesses' rights include the right to be kept informed about the proceedings, the right to be protected from possible harassment and intimidation, right to reimbursement, and right to special measures. While the fundamental aims of the UK criminal justice system, maintaining law and order, administering justice fairly, and protecting rights, have remained consistent, their implementation and emphasis have evolved over time to meet changing societal needs and expectations. For many years, the UK criminal justice system was perceived as being primarily offender-centric, with a significant focus on the rights and rehabilitation of the offender. These often led to the marginalization of victims whose needs and experiences were overlooked. Numerous reports and studies highlighted the negative experiences of victims within the justice system. Victims often felt ignored, disrespected, and re-victimized by the process. Advocacy groups and victims themselves began to call for reforms to address these issues, emphasizing the need for more compassionate and supportive treatment. Recent key legislative and policy changes have therefore aimed at increasing the recognition of victims' rights and needs, resulting in reforms designed to enhance the support and participation in the criminal justice process. However, these efforts had ultimately shifted the system towards the opposite extreme, creating a victim-centric criminal justice system. On the 29th of March 2023, the government introduced the Victims and Prisoners Bill, which has since received royal assent and became law on the 24th of May 2024. The announcement then presented this as a move, part of a radical shake-up of the criminal justice system, promising to cement victims' voices at the heart of the justice system. The announcement stated that the new legislation will stop prisoners serving whole life orders from marrying or forming a civil partnership in prison. Measures previously introduced included tightening rules around open prisons moves, so all indeterminate sentence offenders face much stricter criteria to move from close to open prison, and allowing victims and the public and media to request a parole hearing to be held in public. We have no doubt that some of the challenges we are facing today, such as overcrowded prisons and major delays in court proceedings, flow directly from these key changes. On Sunday, the 7th of July 2024, Mr. Robert Buckland, speaking on the Lewis Goodall show on LBC, expressed support for James Timpson OBE's appointment as Ministers for Prisons. He praised Timpson's focus on rehabilitation and his stance that prisons should be reserved for individuals who pose a danger to society. However, this approval appears somewhat hypocritical given Buckland's tenure as Solicitor General, during which he frequently argued lenient sentences, pushing for harsher penalties where judges of first instance deemed prison unnecessary, only to placate outrage from members of the public seemingly uninformed about the specifics of the case. From what we have outlined so far, we can confidently say that neither an offender-focused nor a victim-focused approach has been effective, and both have led to extremes. So what has gone wrong? We believe that the issue lies in the uniform application of a single priority, whether be an offender-centric or victim-centric approach, across the entire criminal justice process. This method is fundamentally flawed because it does not acknowledge that the criminal justice process is composed of distinct phases, each with its own unique priorities. Therefore, in our view, to achieve best results and ultimately a fairer criminal justice system, a winning formula for reform must consider the distinct priorities and rights inherent in each stage of the criminal justice process. This means recognizing that each phase has its unique needs and goals that must be addressed individually and separately. The criminal justice process can be broadly divided into 4 distinct phases: the investigative phase, the initial prosecution phase, the final prosecution phase, and the sentencing and beyond phase. Each has unique priorities and functions that must be addressed separately for a comprehensive understanding and effective operation of the system. In our view, overhauling the criminal justice system means to recognize that determining what rights must be prioritized within each individual phase is crucial. For example, going back to enhancing victims' rights, whilst this is essential during the investigative and the sentencing phases, it should not interfere with the prosecution phases where the suspects or defendants' rights must take priority to ensure justice is administered fairly and justly. We will delve into this concept in more details later on in this video, so do stay with us until the end to have a better understanding of our proposed approach. Before analyzing each of the phases of the criminal justice process, if you're finding this video interesting, don't just hit it, but in good YouTube slang, smash the like button below and consider subscribing if you have not done so already. This will assist us with our mission of humanizing our criminal justice system. So let's analyze those phases in more details. Starting with the investigative phase, what does this consist of and what are the priorities here? The investigative phase focuses on gathering evidence, which includes collecting, preserving, and analyzing it to build a robust case, which will serve the basis for deciding whether a prosecution is deemed necessary. So it's not building a strong case for the prosecution. This phase must involve securing evidence both for and against the prosecution. And what rights are involved in this stage? The suspect rights must always be upheld, including protection against unlawful searches and seizures and consideration of their specific needs, such as, for example, neurodiversity, drug dependency, mental health issues, etc. These rights must be balanced with the absolutely necessary victims' rights to be heard and to be protected from further harm. Public safety is also a key focus during this stage. Collaboration with other agencies, such as forensic laboratories and victim support services, is essential. However, the most important aspect of this phase is maintaining an open mind. During the investigative phase, the police should not decide whether a crime has been committed and who committed it. Instead, their role is to collect evidence in a lawful manner in respect of the suspect's rights, taking into account the victim's account, and take any necessary but temporary measures to safeguard the public at large and the victim from further harm, and then pass the evidence on to the prosecutor. The initial prosecution phase involves evaluating the evidence provided by law enforcement to determine whether there is sufficient basis to proceed with a prosecution. This includes assessing sufficiency of the evidence, but most importantly, determining whether it is in the public interest to prosecute. In other words, at this stage, a balance must be struck between evidence sufficiency and public interests. While a crime occurrence is always tragic for the victim involved, the public interest must be at the core of this phase. So the suspect interest and the victim's interest at this stage may feature, but only as secondary to that of the public interest. Prosecutions are expensive and place a significant burden on taxpayers and public resources. The question arises, can justice be delivered through means other than a costly and resource-consuming prosecution? We believe that this phase of criminal justice requires more creative approaches, and greater emphasis and focus must be placed in re-evaluating the prosecution mindset. What do we mean by this? When a shocking crime occurs, the immediate reaction is often to demand prosecution and harsh punishment. The public often adopts a lock them up and throw away the key mindset even before a trial has occurred. This is because we put the victim's rights first. However, we argue that victims' rights should not be the primary consideration here. This may seem controversial, but if you reflect on this point, you may see it differently. At this stage, the victim has already been harmed, and that harm can rarely be undone. Any measure taken with the victim's rights in mind cannot be other than a form of retribution or vendetta. Instead, focus should be on the public as a whole. What will best serve the public? Will a prosecution serve the public interest, or is there an alternative solution? Consider cases of rape or sexual assault involving acquaintances, family members or friends, where often cultural, educational and psychological factors are at the core. Do prosecutions of these cases serve the public interest? Should these cases be handled differently outside the traditional prosecution system? Perhaps separate services involving experts in this field could better understand the underlying issues and implement measures that better serve both the suspect and the victim. We need to explore alternative solutions that can deliver justice effectively and efficiently. For example, restorative justice programs can bring together victims and offenders to discuss the harm caused and find a way forward that addresses the needs of both parties and the community. Though forms of restorative justice do already exist in our criminal justice system, these have mostly been used in cases involving youth offenders. Also, they are not well understood by victims and the public at large, and more effort, in our opinion, should be made to educate the public on the benefit of these alternatives, including respect for privacy and specialized input. Similarly, diversion programs can offer treatment and rehabilitation instead of prosecution for certain offenses, reducing recidivism and addressing underlying issues such as substance abuse or mental health problems. In summary, the initial prosecution phase must involve a nuanced evaluation of evidence and public interest. By adopting creative approaches and considering alternatives to traditional prosecution, we can better serve the public at large through cost savings, better resource allocation, and enhanced public safety. By considering diversion for some crimes, the criminal justice system can become more efficient, just and humane, and achieve fair outcomes for all involved. If indeed a prosecution is deemed necessary and in the public interest, then prosecution must be pursued. This is the final prosecution phase. It is essential that this phase focuses exclusively on the defendant's rights. Prosecution, defense, and the judiciary must safeguard the rights of the accused fully by ensuring that all relevant evidence is presented, that legal procedures are adhered to, and that they receive a fair trial. This is crucial to prevent miscarriages of justice. In addition, a very important part of this phase is the recognition of the defendant's right to appeal. This is to ensure that miscarriages of justice can be corrected. This is crucial for maintaining public confidence in the fairness and integrity of the system. Let's now turn onto the sentencing and beyond phase. This phase must strike a careful balance between punishment, deterrence, and rehabilitation. Judges, the prison service, and the parole system all play crucial roles in ensuring that offenders are held accountable accountable and public safety is maintained. However, more focus should be placed on rehabilitation. Opportunity for rehabilitation must be maximized. Rehabilitation focuses on addressing the underlying causes of criminal behavior, such as substance abuse, mental health issues, or lack of education and employment skills. Judges must weigh the potential for rehabilitation when determining sentences, favoring treatment programs, educational opportunities, and vocational training over incarceration. To reduce recidivism, offenders must receive comprehensive support that addresses their challenges and any special needs. This support includes continued access to treatment programs, housing assistance, job placement services, and mentoring. This phase should also heavily focus on victims' rights. Victims must have access to long-term support services such as counseling, financial assistance, and legal support to help them recover and rebuild their lives. Victims must be reassured that the restoration process is ongoing and that efforts are being made to reform the offender. This includes keeping victims informed about the offender's progress and parole status. Community-based programs and restorative justice programs, if discounted at the time when prosecution was considered, can be invaluable at this stage. They can contribute to the offender understanding and accountability and therefore overall rehabilitation. These programs encourage offenders to make amends to their victims and the communities, fostering a sense of responsibility and belonging. The defendant's right to appeal, which includes the right to refer their cases to the Criminal Cases Review Commission if their appeal attempt had failed, is also crucial in this phase. Currently, claims of innocence are dismissed by judges, the prison service, and the probation system. Shockingly, even the very body created to investigate and rectify miscarriages of justice has turned a blind eye. We have indeed already highlighted in several of our videos how a systemic reform to streamlining the appeal process and revolutionizing the Criminal Cases Review Commission has now become imperative. These videos are linked in the description below. However, whilst we give time to the new government to settle and tackle some of the most pressing issues, a culture change must be demanded immediately. Judges must approach claims of innocence and appeals with an open mind, recognizing that errors can occur and that new evidence can emerge. This requires a commitment to justice over finality, ensuring that claims of innocence are fully considered. As well as judges, prison service and parole must also be attuned to claims of innocence. This involves taking allegations seriously, facilitating access to legal resources, and supporting investigations that could exonerate wrongfully convicted individuals. Training programs for judges, prison staff, and parole officers can help foster a culture that prioritizes fairness and openness. These programs should emphasize the importance of thorough, unbiased review processes and the value of correcting injustices. By understanding and prioritizing these distinct phases, we can ensure that each component of the criminal justice system operates effectively, fairly, and in alignment with its specific role and responsibilities. This approach helps to maintain a balanced system that not only seeks to deliver justice but also aims at protecting and rehabilitating all parties involved. So, in summary, we believe that the criminal justice system necessitates a radical shift in culture and attitude. A criminal justice system reform is necessary and must ensure that each phase of criminal justice addresses different rights and priorities. So in relation to the investigative phase, priorities must be collecting, preserving and analyze evidence both for and against prosecution impartially, whilst the rights concerned will be the rights of suspects, including protection against unlawful searches and representing individual needs such as neurodiversity, the rights of victims to be heard and protected, and the right to public safety. In relation to the initial prosecution phase, priorities must be evaluating evidence to determine if there is a sufficient basis for prosecution and, most importantly, if a prosecution serves the public interest. Seriously considering diversion from prosecution in each case. Whilst the rights concerned here will be the right of the public at large through cost savings, better resources allocation and enhanced public safety, and the rights of the defendants and victims, which are indirectly upheld too. In relation to the final prosecution phase, priorities must be fair assessment of the defendant's case and thorough and unbiased review of innocence claims. Whilst the rights concerned will be the defendant's rights to be presumed innocent, to receive a fair trial, and to be recognized a true right to appeal. In relation to the sentencing and beyond phase, priorities must be rehabilitating the offender and preventing recidivism. Whilst the rights concerned here will be the right of the offender to receive humane treatment and the right to appeal and seek review in cases of potential miscarriages of justice, the right of the victim to be fully supported and reassured that the offender's rehabilitation is in their best interest. By tailoring the approach to address the specific needs and rights at each stage, we can create a criminal justice system that is not only fairer, but also more effective in delivering justice for all parties involved. In addition, some aims peripheral to the criminal justice process should also be prioritized and enhanced. On one end of the spectrum, this includes prioritizing crime prevention by proactive engagement of law enforcement agencies with communities to address local concerns, by designing youth programs aimed at educating about the consequences of crime, by providing job training and employment opportunities to vulnerable groups to reduce incentives for criminal behavior, by offering programs that identify and support individuals with mental health issues or substance abuse problems, by ensure that mental health and addiction services are readily available and affordable, by engaging the community in the development and implementation of crime prevention programs to ensure they meet local needs and gain public support. Actions peripheral to criminal justice also include focusing on accountability and oversight for those administering justice. It is essential to ensure that agencies responsible for investigating complaints of misconduct and malpractice within law enforcement, prosecuting bodies, or judges, such as the Independent Office for Police Conduct, the IOPC, operate with true independence. Additionally, consideration should be given to involving the public in these investigations through mechanisms such as public inquiries. In conclusion, we believe that our criminal justice system is capable of reform, and our proposed reformed criminal justice system must prioritize 5 main areas: preventing crime, considering prosecution only as a last resort, prioritizing diversion, reforming offenders, offering comprehensive support to victims while educating them and the public at large on the benefits of rehabilitation over retribution, enhancing accountability of those who administer justice. This proposed reform will achieve its crucial aim of maintaining law and order whilst upholding the rights of all those involved in the process. It not only provides justice for victims and the society as a whole, but also deters criminal behavior, contributes to offender reform, and upholds public confidence in the rule of law. This comprehensive approach helps ensure a safer and more orderly as well as more just society. I hope you found this video comprehensive and balanced, and if so, like it and consider subscribing to join us in our mission to humanize the criminal justice system. Also, join our networking hub to participate in drafting proposal for reforming our criminal justice system, which we can present to those who have promised us change. We echo their call. Change is imperative and must happen now. Join us again as we sit and rise in this unique trial.